Hi, I'm Alexander Haberbush, president of the Lex Rex Institute and a practicing attorney in the area of constitutional law. And this is a presentation of the Lex Rex Institute, where we're committed to the fact that the law is our only king and that everyone is subject to it, even our leaders. As always, nothing in this video constitutes legal advice, but we are happy to give legal advice, and we do offer free 30-minute consultations. So check out our website, lexrex.org, if that's something that you're interested in doing. But let's jump straight into our question for today. All right, so this week's question is, how does a case end up being heard by the Supreme Court? So sort of a procedural question, and I know procedure is probably what everybody finds most interesting and compelling in the law. But don't worry, I'll try to make it as interesting as possible, and we will dive right in and take a look at that. Okay. So before I dive into the nitty-gritty, big picture answer to that question is that there are two main ways that a case will make its way to the Supreme Court. The first is through what's called the Supreme Court's original jurisdiction. What that means is that the case starts at the Supreme Court. It's never been heard at a lower court. This is the first time that any court is looking at the question. And the second way is going to be through the court's what's called appellate jurisdiction, which means that the case is one that has originated in a lower court of some kind, whether it's a state Supreme Court or usually it's going to be one of the circuit courts, the federal courts of appeals. And then the case has been appealed to the Supreme Court through what's called a petition for writ of certiorari. Now I'm going to get into a little bit more of what those things mean, but let me first just say that address some common misconceptions there might be about what the Supreme Court does. So obviously this question has to do with the concept of judicial review, the idea that the court will look at and examine laws that Congress passes and decide whether or not those laws are consistent with the Constitution. A few years back, a friend and I were having a conversation. We were talking about, I think, a law that had just gone through Congress. I'm not sure if the president had already signed it or if it was still waiting on his desk, but at any rate, it's a law that was, or a bill that was almost certain to become a law in the near future. And we were talking, and somehow he asked, you know, it's gone through both houses of Congress, president signed it, but when does the Supreme Court hear that? And I kind of looked at him and I said, well, what do you mean? When does the Supreme Court hear it? He says, well, you know, they have judicial review. So when does that law go to the Supreme Court? See, he thought that the Supreme Court functioned as one step of our process of making a bill into a law. So, you know, it goes through both houses of Congress, the House and the Senate, or vice versa, and then it goes to the president who signs it, and then it goes straight to the Supreme Court who decides whether or not it's illegal. That's not how it works. And the reason that's not how it works is because the Supreme Court is a court of limited jurisdiction. Now that might sound crazy to you because, you know, it's the highest court that hears all the important cases, all the big cases, right? Well, yes, but also no. Because any court, any body in our government must be empowered by the Constitution to exercise any power that it may have. What we call that is jurisdiction. And if we take a look at Article 3 of the Constitution, let me pull that up right here. Article 3 sets the jurisdiction of the Supreme Court. In fact, it sets the jurisdiction of all federal courts. And significantly, what Article 3 of the Constitution pertains to is cases in law and equity. In other words, the Supreme Court can only hear cases and controversies. That's why it doesn't just review every single law that ends up getting passed by Congress. It has to be something that someone first disputed. There had to have been a lawsuit that took place. Otherwise, there's not a case in controversy, and the Supreme Court is only empowered to hear cases and controversies. So, what do we have in the next sentence right here? Arising under this Constitution, the laws of the United States, treaties made or which shall be made under their authority. Okay, so what does that mean? Well, Constitution, we know what that is. The laws of the United States. So laws of the United States are going to be federal laws, laws that are made under the Constitution. So laws that are empowered to be made by the Constitution and which are ultimately subject to the Constitution, as well as treaties. So that's distinguishing. We don't just mean federal statutory law here. We mean treaties that are made with other nations as well. So what does that mean? Well, it means the Supreme Court's jurisdiction is limited to cases and controversies about federal law, about federal matters. Supreme Court cannot hear matters of state law. State courts are going to be the ultimate arbiters of state matters. Well, that might sound weird to you, right? Because the Supreme Court's supposed to be the highest one. Yeah, that's true, but again, remember, we live in a federal system. So state sovereignty, state power is always going to be distinct and kept separate from federal sovereignty or federal power. So we're going to keep state courts the arbiters and interpreters of state law and make Supreme Court, federal courts the arbiter and interpreter of federal law. Now, significantly, also in Article 3, by the way, I should mention, Article 1 of the Constitution is the legislative branch, that's Congress. Article 2 is the president, that's the executive branch. Article 3 is the judicial, and this is by far the shortest of those three articles. It's barely over a page in length if you look at this document that I'm looking at here. Why is it so short? Well, because the majority of things that our courts do, they were already doing prior to the ratification of the Constitution. The common law continues to apply. Most people knew how courts worked. Most of the framers of our Constitution were lawyers, so they just kept things working the same way they already did. Didn't need to be spelled out in the same kind of detail that the President and Congress needed to be. So that's why it looks like this. And significantly, when it comes to judicial review, remember, we talked about last week, that principle first originated way back, I think in 1609, during the Elizabethan reign in a case called Dr. Bonham's case, which was actually litigated by Sir Coke, one of the most famous jurists in the history of English and American law. Okay, so taking a look a little bit further down here, we will address what I referenced at the beginning of this video, which is the original jurisdiction of the Supreme Court and appellate jurisdiction of the Supreme Court. Now that we've talked about its jurisdiction more broadly, cases and controversies about federal law, how do cases actually get there? Well, that's going to be through original jurisdiction and through appellate jurisdiction. So here we've got in cases affecting, we'll talk about original jurisdiction first. I think it's a little bit simpler to understand, although understand original jurisdiction is going to be far and away the less common of the two options. By far the majority of cases get to the Supreme Court through writ of certiorari. But let's take a look at the original jurisdiction of the court. In all cases affecting ambassadors and other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Okay, so two broad categories here. First is going to be ambassadors, public ministers, and consuls, and second is going to be states. Now, look at these. They're a little bit different. Well, how are they different? So for ambassadors, and just so you're aware, public ministers and consuls basically means people who exercise diplomatic powers under the Constitution. So it's very similar to ambassadors. It doesn't mean every single politician is a minister. It has a specific meaning. Supreme Court has interpreted it that way. So, okay, what's the difference between the ambassadors clause and the states clause right here? That's not official names or anything. It's just what I'm calling them. Anyway, so we see for ambassadors, it's all cases affecting them. Whereas for states, it's cases in which they are a party. Well, what's a party to a case? That would be plaintiff, defendant, somebody who's actually named on the lawsuit. But what's a case that affects somebody? It's a lot broader, right? I mean, you might be affected by a case in which you're not a party. And the Supreme Court's actually said that that's true. There are some cases which can originate at the Supreme Court, even though an ambassador or public minister and consul is not a party. Also significantly, the fact that it says affecting here means that it is actually more limited than the party requirement in some circumstances. Because, for instance, say an ambassador is trying to divorce his wife. Is that a case that's going to have to start at the Supreme Court? No, of course not. In fact, those are almost never going to get to the Supreme Court because affecting an ambassador or a public minister can be presumed to mean affecting them in their official capacity, something having to do with their powers as a diplomat under the United States Constitution. And the Supreme Court has interpreted that way. Now, for a state, it's going to apply to any case in which a state is a party. And this actually happened fairly recently in a case that's Texas v. Pennsylvania. You may have heard about that one in the news. That was Texas's challenge to the way in which several states had conducted the 2020 election. And that case, as you may recall, went directly to the Supreme Court. Now, something to keep in mind when looking at original jurisdiction, because this is not true of appellate jurisdiction. But in all cases that pertain to original jurisdiction, that's purely constitutional. That is something Congress cannot expand or contract. Congress can't say we want patents to be in the original jurisdiction of the Supreme Court. We want patent cases to go straight to the Supreme Court. That's something they cannot say. Where that's not going to be true when we're talking about the appellate jurisdiction of the Supreme Court. Now, going back to that 2020 Texas v. Pennsylvania case, it was previously an unsettled matter whether or not the court could reject cases brought to it in its original jurisdiction. And a lot of legal scholars would have told you they can't do that. However, when this case ends up going to the Supreme Court, 8 of the justices say, no, we are going to reject that case. They said that Texas hadn't shown standing. You know, I've got my opinions about whether or not that was pled effectively or whether or not it could have been pled more effectively, but we won't get into that today. But they said that the case lacked standing, Texas lacked standing. So, and the court was not going to hear the case. Now, Justice Thomas, the lone dissent in that case, said what I think had certainly a plausible constitutional argument for it, which is that the court cannot change the original jurisdiction of itself. It can't control its own jurisdiction. Therefore, it's required to take cases within its original jurisdiction. That ended up not winning the day, but that's something to be aware of. So this idea that Congress cannot modify the original jurisdiction of the Supreme Court is actually a very old, well-accepted constitutional idea. As early as Marbury v. Madison, one of the most important cases in constitutional law, this was recognized. This is going to be very different from the appellate jurisdiction of the Supreme Court, so let's take a look at that right now. Remember, appellate jurisdiction is a jurisdiction over cases that come to the Supreme Court that have already been heard by some other tribunal. Okay, so that's actually going to be the very next sentence of the Constitution. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. Okay, so several things to be aware of here. First thing is that it pertains to all other cases in which the Supreme Court has jurisdiction. So those are going to be the cases mentioned up here, ones that are under federal law, essentially. So federal law cases. And it's the trier of both law and fact. We'll explain what that means in a couple minutes. But here's the difference from original jurisdiction, because appellate jurisdiction of the Supreme Court is actually subject to whatever regulations Congress shall make. Now, what does that mean? Well, what that means, practically speaking, is that Congress can actually restrict the jurisdiction of the Supreme Court, and they have done this from time to time previously. Most famously, this was done in Ex parte McArdle, an 1868 case. It was also done as recently as 2006 in a case called Hamden v. Rumsfeld, which was a case that pertained to Guantanamo Bay detainees. Congress had said that the Supreme Court lacked jurisdiction over those detainees, and the Supreme Court disagreed with it in that case. So even though in Ex parte McArdle, the ability of the Congress to limit the jurisdiction of the Supreme Court was upheld, we know that that power is not absolute. There are some matters over which Congress cannot limit the jurisdiction of the Supreme Court. You probably wouldn't know that from the text of the Constitution, since it just says under whatever regulations Congress shall make. But that's the way the precedent has gone on this. Additionally, worth noting is that only applies to the Supreme Court. Congress does not have the ability to limit jurisdiction of lower courts, or likely doesn't. That hasn't really been heard that much by the courts, since Congress hasn't really tried to do that too much. But how does a case actually get to the Supreme Court through its appellate jurisdiction? Well, I'm going to show you something else. Let me pull it up. So here's a map of all of the different judicial districts and circuits in the United States. And these are going to be all of your federal courts, the way they're divided here. So you see district courts are going to be like Southern, Central, Northern, Eastern California. Some states just have one district, a lot of the ones over here. And then the circuits are going to be the courts that preside over those courts, 9th, 10th, 8th, 5th. There's going to be 12 of these judicial circuits, and there's going to be 94 total district courts in the United States. So how does the appellate process work? Well, let me start to you by explaining how the appellate process works in state court, because remember, we're a federal system. State courts are separate and distinct from federal courts, but the appellate system works very similarly in both of those instances, except that, remember, state courts can hear both state and federal matters, whereas federal courts can only hear matters of federal jurisdiction, so usually matters of federal law. Also, there's other ways like diversity jurisdiction. If plaintiff is from one state and defendants from another, then it can be heard in federal court, but usually matters of federal law, whereas state courts can hear both matters of federal and state law. So in the states, how does the appellate process work? Well, lower courts are usually going to be your trial courts. So trial courts are going to have a jury of 12 people as your finder of fact and a judge as your finder of law. There's also bench trials too, where a judge finds both fact and law, but usually it's going to work where there's a jury and a judge. Now, what does that mean, finder of fact versus finder of law? Well, say that the defendant is accused of murdering somebody. Jury is going to answer questions like whether or not that person actually killed the victim of that case, whether or not they were the person that committed the crime or whether it was potentially somebody else. They're also going to determine whether or not this was the knife that was used in the murder. So if we know the person was stabbed, there's 5 different knives, and the prosecutor is saying it had to be this knife, the defense is saying it couldn't be this knife, that's going to be a factual matter. That's something that a jury has to decide. Legal matters are going to be decided by the judge. So what's a legal matter? Well, a legal matter is going to be what constitutes a killing. Things that, what constitutes the law in question here. So if somebody says, there's no statute of limitations on murder, but they say that this is past the statute of limitations, judge would decide whether or not that applies here. Or something like, say that the victim was stabbed and then died 2 years later, and the doctors say it was as a result of wounds that were sustained in that injury 2 years earlier. A judge is going to decide whether or not that is sufficiently remote that it no longer constitutes murder. That's a legal matter for the judge to decide. Now, on appeal, this is going to go to state courts of appeals. And so again, all of these state courts are going to be organized under the state constitutions. The system works a little bit differently in each state. So I'm not going to get into a great deal of detail about the appellate process, except to say that there are usually courts of appeal where just judges hear a case. And then there's going to be a Supreme Court, the highest court in each state, that will ultimately decide matters that are appealed to the Supreme Court. Now, not all state Supreme Courts are called Supreme Courts. Significantly, and this is actually going to help you out in reading the news, all of the state of New York's lower courts, their trial courts, are called Supreme Courts, whereas their Supreme Court is called their Court of Appeals. So a lot of times you'll see articles that say things like, New York Supreme Court decides XYZ. That just means that the lower trial court in New York, some lower trial court somewhere in New York decided something. So be aware of that when you're looking at news articles. But that's sort of how the appellate process works in the state courts. Now let me pull up that map again. Federal courts are going to be very similar to that. There's going to be your lower court or your district court, which is going to be in each of these districts. So things will be heard by Central District of California, or things will be heard by the District of Arizona. And that's, again, going to be a jury of 12 people and a judge for most matters, where the jury is the finder of fact and judge is the finder of law. On appeal, your circuit courts, so that's the numbered ones here, the different colored sections, your circuit courts are always going to be comprised of 3 judge panels. Now, there are obviously more than 3 judges in each district, but in each circuit, but for each case, they're going to appoint 3 judges, and that they're going to form a panel, and they're going to hear the case. And cases can be appealed after a final verdict is rendered in the lower court. They can be appealed to the circuit courts, who will then hear the case and make a final determination. Now, at that point is typically when you're most commonly going to get your petition for writ of certiorari to the Supreme Court. But it actually doesn't have to take place then. You can file a petition for writ of certiorari whenever you want, actually. There's nothing compelling the Supreme Court to have final adjudications of matters before they hear something. Now, usually they are going to deny cert if the matter has not been fully adjudicated. So if one of the circuit courts has not rendered a final judgment on something, but you can appeal whenever. And sometimes they actually will take things that are appealed prior to a final adjudication. An example that comes quickly to mind is Bush v. Gore. That was when Al Gore had challenged the election results in the state of Florida in the 2000 election. That was obviously a very pressing matter to be heard quickly because you wanted to do it before any of the state electoral colleges had met. And the Supreme Court did end up hearing that prior to a final adjudication. So they can do that, but there's got to be some compelling reason for them to do it. Something like a severe time constraint, or it's a matter of great national significance. Most of the time, vast majority of the time, cases are going to be heard on a petition for writ of certiorari after a final adjudication by a circuit court. Also, less commonly, though this does still happen somewhat frequently, a case is going to be heard on a petition for writ of certiorari after a final adjudication by a state Supreme Court. So those are the 2 most likely places you'll appeal from: Circuit Court of Appeals or a state Supreme Court. And it can go from a state Supreme Court if the case that court was hearing was a matter that substantially involved federal law or where federal questions were significantly implicated, something of that nature. Obviously, the reasons why it would be appealed from a circuit court are going to be a lot more obvious. So, how does the Supreme Court decide which cases it's going to hear? Well, they don't take that many of them. for one thing. Usually they take about 1% of the cases that they receive on petition for writ of certiorari. By the way, certiorari just means basically to be more fully informed, or to be more fully informed of something. I think it's Latin for like to more fully inform. And it just means you're making the Supreme Court aware that a case exists. So when they've been made aware of those cases' existence, they take about 1% of the cases submitted in that manner, which equals about 80 cases per year that finally make it to the Supreme Court's calendar. And these cases, the ones that get on the court's calendar, are ones where at least 4 justices have said, yeah, I think we ought to take that case. This is called the rule of 4. And that's how the justices decide whether or not they can take a case. Now, what sort of criteria do they use when deciding whether to take a case? Well, let me pull up that map again. So most common sorts of cases the Supreme Court's going to take are going to be cases that involve a conflict of law or a conflict of finding between different jurisdictions. So say that the courts are hearing whether or not prayer can be allowed in public school. It's a big contentious issue right now. And the Ninth Circuit has said, no, you can't pray in public schools. Or the 10th Circuit has said, yeah, it's fine to pray in public schools. Maybe the 8th Circuit has said, no, you can't pray in public schools. Their reason for that is different from what the 9th Circuit said. Well, the Supreme Court doesn't like it when the Constitution is interpreted differently in different sections of the country. So when there are circuit splits like that, that's going to be your most common reason why the court would want to hear a case. Other factors that are going to be significant are things like if the rights involved are very significant rights, or if it's something that's a very important issue to the public, something like freedom of speech, freedom of religion, or another one's going to be if it's something that substantially involves the rights of states. So if there's a conflict between state and federal law such that states may potentially be deprived of certain liberties that states are supposed to have under the Constitution, or at least there's a legal question that they might be. So that's sort of how the Supreme Court decides which cases to take. Those are the ones that get there. Hopefully that answers your question. Again, to summarize, 2 basic ways: original jurisdiction and appellate jurisdiction. Original jurisdiction are going to be cases that go straight to the Supreme Court. Appellate jurisdiction are going to be ones that get there on appeal. So those are the 2 ways cases get there. Again, original jurisdiction is just sort of cases where states are parties, or cases that affect ambassadors and other diplomats, where appellate jurisdiction is going to be all the rest of those cases where Congress has not explicitly said these cases are outside your jurisdiction, which is practically speaking darn near everything right now. So that's how they get there. They have to be appealed to get there on a petition for writ of certiorari. And that's sort of summary of what we went over today. So if you enjoyed this video, please click like. Also make sure to hit subscribe and click on the bell icon for notifications. If you appreciate what the Lex Rex Institute is doing, and we do a lot to defend these sorts of procedural issues. I know they're not the most glamorous, but they are extremely important. Judicial procedure is integral to defending our rights. So if you want to defend this sort of thing, please go to our website, lexrex.org. We always appreciate contributions. And again, nothing in this video constitutes legal advice. I'm Alexander Haberbush, and this has been a presentation of the Lex Rex Institute.